Okay. Good morning. This is the domestic violence docket to make sure you're in the right place. There's other courtrooms that are having matters going on at this time.
Did you get all my email?
If you're not sure, you can raise your hand and I'll see what you're looking for. What do you look, ma'am? You raised your hand. You look kind of familiar though. You're not sure if you're in the right place?
I'll talk to her on her.
Oh. Okay, wherever you are.
Mr. Kreider? He's very monorail looking for a crazy person. I'm like shocked.
Okay, so is everybody else
Let's see, is form-
maybe you're waiting for your client to show up?
I'm waiting for a prosecutor,
Prosecutor, okay.
Mr. Randall.
Your Honor, we do have a pro se, but it's a diversion injury, so I'm gonna wait for my other coworker to go over it. But that's, you got it.
Okay. I guess.
They're mine.
Oh, okay. There was you. Okay. I'm sure your attorney will be here in a minute. Uh-oh. Wait. Oh. I have a Benson Sipes is here today, S-I-P-E.
Austin Holmes?
Oh yeah, that one. We're just set.
4.
Motion to vacate.
No, it may just.
Yes, sir.
This was a 91.
Well,
This is a 1991.
could have came back a little sooner.
But it does look like he's had no new crimes. We checked the JIS, the NCIC. They pay everything off. He's had no prior vacations.
Okay, do you have the proposed order, sir?
Would that be this people? Just everything they gave me.
Yeah, I looked and I saw.
I'm looking at sometime, I don't know that it's scanned in or it's scanned in, I guess I can sign it digitally or,
I don't know why they never give them the order. Do you want him to?
well, I don't have, it says proof of service, compliance, hearing notice. Here it says motion in order to vacate, but,
She's gonna print one.
okay. I gotta check off about 10 boxes on it or something.
How's your weekend?
But what was the charge?
It's all in the fourth degree domestic violence.
I'm looking to see, I gotta write that in, I think, just a second. Additional one, you should check for additional waiting 5 years. He's never been restrained by any other no contact order, anti-harassment, et cetera, I guess, within the last.
And there isn't a third one. I don't know where that happened.
Oh, it's over there. I'll just go sit over here.
I can go over there.
Oh, no.
Hmm.
Let's go.
Again, it's, there's just one count one, right?
Think so?
Was just, one count, just count one? I don't have the charge on it. So it's assault. Did you plead guilty? Do you remember?
Yes, sir.
Versus not having a jury trial?
Should be over here. I think Morris is 15. She says.
Oh, yeah, you're right.
Okay, on the last page, you can just sign it as defendant, print your name, and your date of birth is 10/3/1969.
Yes, sir.
This come up in, looking for a job or something, or?
Oh, it comes up when I background check to volunteer at the school. They've still let me, but
Hmm.
I just read that.
So-
It's not an issue anymore, obviously.
Okay, here's the last page that you can sign and print by my name and.
Yeah, sign.
Oh, were you here?
Yep.
Zootopia. No. It was on Netflix. I watched it this weekend. It's in the trailer for like the main character body around it goes into a DMV like all of town like people, customer service people are slobs. Oh my yeah, I saw that part. And I didn't think about that. It's kind of like answer questions that it's really funny. Rabbits are listening.
Thank you, Your Honor.
Welcome.
James Watson? This is James Watson. He is appearing for readiness today. He'd like to enter a change of plea pursuant to a pretrial agreement.
Okay. So it's going from assault 4 DV to disorderly conduct DV, is that
Correct.
what I see here? Again, why do that if, you could, I guess, tell me what happened or
So,
what the incident's about, please? Thank you.
yeah, this was originally charged as an assault 4 DV. It stems from an incident between Mr. Watson and his domestic partner, longtime
Oh.
girlfriend,
Lady,
Michelle
okay.
Flowers. They were both drinking that night. They had separated a short time before this incident happened. While they were separated, Ms. Flowers essentially had an affair or became involved with one of Mr. Watson's best friends.
I kind of recall this. Is this at a barbecue or something? She told him that?
They were, yeah, they
some
were
party
drinking one night.
gathering.
And she told him that, obviously, probably not a good thing to be happening while both of them were drinking. And unfortunately, Mr. Watson reacted by slapping Ms. Flowers. Prosecutor's office and I have both been in contact with her. She's not recanting or anything like that, but she does think that this is a fair resolution.
She's been in front of you, Your Honor.
Yeah, I mean, I recall hearing the fact pattern. She come in and asked to have the no contact order
That's
dropped in
correct.
probably.
It's been since
It's,
rescinded, Your Honor.
yeah, it's been lifted.
Okay. Need to find them. Well, it's the July 26th amended information.
That would be the one that I have in front of me as well.
Right, to amend that one. Okay, she's not present here today, right?
I'll call out, Your Honor. When I spoke to her, she indicated she
Okay,
may
she's
be.
not.
I don't know if she's.
What's her name? Flowers?
Michelle Flowers?
She wasn't.
What was the last name?
She wasn't
Flowers.
feeling well, so she.
Fine. Okay. Make the amendment here and type that in.
Wow.
Didn't you
who
got
was that?
arrested and, or did you, right? Did a day or some time in jail?
He did a day when he was booked in from July 25th to July 26th. He also did an additional day on a supervised release violation, so
Yeah,
he
that's
should
true.
have 2 days credit.
And that's what the state has calculated as well, Your Honor.
Wait,
2 days total?
whoever has VAR today, they have 30. That's not fun either.
Hmm. And we intend to go through sentencing now, right?
Yes, Your Honor.
Right, so I gotta type all this stuff in about the change in the RCW, so forth. Got it done now, okay. Amended disorderly conduct, DV 9A 84030, you pled and sentenced. You went over this with your attorneys to understand what the recommendation is that correct?
Yes, sir.
I think it's slightly different, your benefit, it's gonna be 88 suspended instead of 89, right? We said 2 days is what he spent.
Correct.
Most of the other conditions we'll cover, they've pretty much been changed to nothing, right?
They'll, need to complete an alcohol complex.
Okay, I guess that one. The other three were crossed out or something.
Correct.
Okay, you're 48 years of age, sir. You've have attended some college. Ms. Hawk as your attorney. Pleading guilty, you're giving up all the rights contained in paragraph 5, A through F about speedy public trial, confrontation, compulsory attendance, presumption of innocence, and you can't appeal because you're pleading guilty. So you don't get to hear witnesses or anything like that because there's no trial. So again, you've read through this entire document. You want to plead as charged. Is that correct?
JIS.
For the factual basis, you said on July 25, 2016, in the County of Clark, State of Washington, I used threatening or abusive language, thereby intentionally creating the risk of an assault towards my girlfriend, Michelle Flowers. Okay? Guess let's cover anything else from the state or state case, I guess.
Your Honor, we just asked you to file a pretrial agreement. It's our position that this was a case that was driven by alcohol. We think it's a fair resolution. Been in contact with the victim on the one.
Are you two back together? I can't remember if you lived together at the time
Yes.
or
Yes, Your Honor.
now are.
We're still,
Pardon?
yes, we're still together. We live together.
Things going okay?
Yeah. It's going great.
Hope so. Because, let's see if you have a prior record now that, things get worse when you come back with some history. Okay, you have a right to speak. You don't have to say anything if you don't want to, but if you want to talk or you thought your attorney, whatever, didn't cover something you wanted to cover better, but it's not like she covered it all, you can say something too. Okay. I'm going to follow the recommendation, which is 2 days in jail. 88 days is then suspended. You're employed
Yes, sir.
as,
Pardon me?
you do what?
I'm a low voltage technician.
Okay. So you work for a company or whatever. Okay, $100 is the fine amount. $43 is the court improvement amount. $150 is what's called the indigent defense or for the attorney. And the DV assessment is $100. So while you have 6 months to take care of that, less than $500 obligation, whatever it is, 400 something. 2-year bench probation. No similars. Have a substance abuse or alcohol evaluation. That's what the evidence was, that they're both drinking, and
Correct, Your Honor.
and she doesn't want restitution. There's no medical
No.
injury or expense or something like that. Okay. Looks good. Thank you. So you'll step over to the your left at the computer terminal there and sign for your judgment and sentence.
Try to just get it from them.
And we're waiting for what? Get prisoners? Any prisoners coming? No, there's one. So, anybody?
I have one more matter to call. It's just an FTA. Patrick Morris, he's incarcerated in Yakima County. Will not be here.
Are you sure he's not coming late? It's kind of early to call warrants.
Double checked the jail roster for Yakima County about 10 minutes ago. He's still incarcerated
Did you
there.
expect him to be in Yakima County or
What was that?
something? Did you expect him to be in Yakima County?
I knew he had a pending case up there. I'm not sure how or why he got taken in.
I'm just saying, if you have to check the jail, all 39 counties, or you just thought he'd be there?
I just found out which county his pending charge was in, and I
Oh.
made an educated guess. He does not have a projected release date
Okay,
yet,
what was-
so I can't give a good time for when.
Do a warrant. What'd you say is
Patrick Morris.
Morris?
For readiness.
There's
That's
two
fine,
cases,
Kevin.
Your Honor. 313269.
got out,
We got Thursday, Friday.
was he here? I have, yeah, he's listed so many times here because of the different things, motion to join, motion to amend. He's on here 5 times or something, but just 2 case numbers, 313269, and then the other is 145330, right? Does? Oh.
Is that for,
What's the amount on that one, if you know?
It was a $5,000 bench warrant. It was issued, he failed to appear at his bail surrender hearing on August
Oh.
16th.
That's correct.
He was also stolen.
So on 313269, so anyone want a warrant on then? So what is the charge in Yakima County?
Failure to register?
Okay. And, let me look, this is. Where are you joining? You're joining you're trying to get what?
I think this was a case, Your Honor, where it was, looks
No
like at least
contact
an
order?
initial charge of assault for, not familiar with the case, but just looking at the dates, it looks like approximately 3 days later, he picked up a allegation of a no contact. It looks like it was the city's position, since these were both set for trial, to join them, more likely than not in the interest of judicial resources. It looks like many of the same, particular victim is the same victim. Strike that last one.
What do you want,
Oh, yeah.
motion to add on, you can add on bail jump or not add bail jump?
At this time, I think just given that the information is that he's in another county in Yakima, I just asked the court to strike the trials, issue a bench warrant. I'll defer to the court regarding the amount on the bench warrant. I'll leave it up to Mr. Fair if he ends up wanting to go forward with a bail jump. I'll let him kind of maybe begin that when he turns himself back into Clark County and begin negotiating. I don't know if this was a case that was likely to go, but given again the information provided to the court, we'll refrain from asking the court for bail jump at this time.
Okay. Yakima County Jail. I was just curious if there's some new locator device where you can put someone's name in and find out what jail they're in, and you gotta check every county jail system.
I just looked up his JIS and popped in the court code for where he's been.
Oh, hey, you're here.
Um, you know, is he from Yakima? Is he, resident here or something like that, or is he's intending to come back probably eventually?
It looks like, according to the amended citation filed on, or about June 30th, it had listed a Vancouver address.
Okay, I'm gonna do a book and hold. Because need to get the case taken care of, and if it's a bail, sometimes even if he's arrested, they won't book him because it's a crowding policy.
Taken off diversion.
Your Honor?
Thank you, Your Honor.
Welcome, that's only on the 3269 case, is already worn out on the other one.
Josh Kreider. Mr. Kreider's making his way forward. This is case 5Z11777065. Mr. Kreider is going to be pleading to a violation of a no contact order. As noted on the PTA, it is going to be free to argue on deferred, so when sentencing comes, we just ask Your Honor to allow argument.
He's pleading his charge, correct?
Yes.
Defining, so there's an amended second. Amended that many times.
I have to go to jail.
Well, there is one, no, then we don't have it right, I mean,
So both of them left me voicemails. It's like,
There was one file.
Plea bargain isn't correct in that it doesn't cover the second count of bail jump. Is that to be dismissed then? Right?
Yeah, he turned himself in.
Okay, no. I assume it's just 2 counts. I gotta go to the
That's
second
correct.
page.
It looks like the second was filed on May 24th, Your Honor.
Right. Okay. Just a second. Go ahead and, I guess if you wanna write on that, dismiss count 2 or whatever. I'll go ahead and do that.
And I would love to start writing.
So plead to count 1, dismiss count 2. Got it. We'll get into the factual basis in a second, I guess, but the, that's a long, I don't understand. Is that a civil? It says it was in cause number 15H0. That's an unusual looking number to me.
Yes, it was a civil
Is that
anti-harassment order that she had applied for.
out of Clark County.
Yes.
Correct.
And it was a temporary one, and there was emails sent essentially, and that's the factual basis. And they had been in a dating relationship.
Okay. Okay, and she is whom?
Yeah.
Pardon?
Just trying to post it over the name.
You don't,
Deanna
yeah, it's not tight.
Amadee. And again, it was a prior dating relationship.
Right, I mean, her name's not listed in any of the charging documents. Is she present here today?
I don't believe so, Your Honor.
Still your girlfriend
Ex-girlfriend.
or ex-girlfriend? Okay.
This was not a case of mutual consented contact.
Oh, okay. No longer your girlfriend, I guess, or whatever. Okay, you're 36 years of age, is that correct, sir?
Yes.
Okay. You've completed some college. Okay, you have Ms. Whitney of Vancouver Defenders representing you. You've given up all the rights contained in paragraph 5, A through F about speedy public trial, confrontation, compulsory attendance, presumption of innocence, and the right to appeal a finding of guilt after trial. And again, you want to plead guilty as charged, as on or about November 24th. This was a while ago, 2015 in Clark County. City of Vancouver, you knowingly violated a valid no contact order by sending a temporary anti-harassment order by sending an email to my ex. Yeah, GF, I guess, right. Why'd you do that?
Your Honor, they were selling a house or in the middle of trying to like divide property. This was right after the breakup. He was served with this order. He sent an email trying to kind of get everything finished. And she did not want contact, so it was not mutual. However, it wasn't anything in a threatening manner. It was trying to separate property and, it sounds
Did you own
like-
a house together or buying a house?
We were gonna purchase a house, so figured that out.
Forgot if you were, you weren't, or getting your
We had
deposit
a
back?
credit
I
card
mean,
together, and I was curious about the separation of the credit card.
How many days earlier had you been served by the sheriff or whatever?
Not quite sure.
Couple? Or I mean, you hadn't yet had your hearing though. I mean, you get served, then you have a hearing within 14 days, so you hadn't had the permanent hearing yet, right? I presume?
I didn't,
It's on-
I didn't go.
It was temporary. If it was a temporary, it means you just got served, I think, is what we're talking about here. Then your hearing would have been within 2 weeks, and sometime within that 2 weeks, you sent her an email asking about the divvying up of credit or whatever.
It looks like
That
it was
is?
served on November 4th from what the police report says. So it may have been, he's been served with temporary, but he didn't go to the other hearing.
I think she petitioned the court around the 21st of October. It's cited for this violation approximately in 1 day, Your Honor.
What? That would be 3 days. I just missed some. Anyway, I guess it'd still be a violation, but I don't know if it was it actually the temporary or was it the permanent one? If he didn't show up to the hearing, it was more than 14 days past the temp, then it'd be a permanent anti-harassment.
I think
wouldn't it?
when I get to, my argument, Your Honor, I'd have to refresh my recollection. This is a case that's been exhausting to some extent for the city, mostly just because of the amount of resources we've had to spend. So I honestly don't have a recollection as to, off the top of my
Amount
head.
of resources you had to spend to do what?
I can get to that when the court's ready.
Okay, I've accepted his plea of guilty. I just want to make, if it matters, you said violated a temporary. It almost sounds like it wasn't a temporary if he didn't show up for the hearing. And they're saying on one day he got served and he violates this 20-some other days. It seemed like there would have been a permanent order by that time. If things normal go to, of course, maybe he wasn't
It looks
served
like
or
it
something.
would have been, Your Honor, on the 4th they issued a permanent.
4th of
contact order.
4th of December?
November, Your Honor.
Okay.
Dated
Either way.
November 4th, 2015 at 9:30. Expires a year from that date, 2016.
So it wasn't a temporary anti-harassment, it was a permanent anti-harassment, I think.
It's an anti-harassment order.
It was probably worse if he went to the hearing, the judge told him to stay away, and he still went back. But, okay, I'll find as a factual basis, accept his plea of guilty, be it a temporary or a permanent. It sounds like
No way he
permanent.
wasn't supposed to have contact.
Yeah, go ahead, make your argument.
I'll let Mr. Randall make his first.
Okay.
Yes, Your Honor, this is a case that essentially now 2 prosecutors have been assigned.
Is it a global?
Things I'd like to do, I'd like to let the court know, kind of comment regarding the resources.
Looks like it is.
There's also a letter
Check
that
it,
Rebecca submitted with the court when she did her, I believe it was the temporary no contact order that I'd like to read into the court. The aspect that we're doing a free to argue on is whether or not to do a deferred sentence or not. I was willing to do a free to argue, not because I think a deferred sentence is appropriate in this situation. I think it's the opposite. It's just rather than go to trial on that really being the only issue, whether or not to do a deferred, I thought it was probably best to just do a free to argue and avoid judicial resources as opposed to going to trial just to essentially litigate or argue an issue that would be addressed at sentencing. I'll read a letter that I don't know if the court, and I can certainly hand this up. This is again from the victim. I'm writing a brief summary of the last 5 months. Now this is dated October 21st, 2015. Summary of the last 5 months of unwelcome harassment from Joshua Kreider. On June 15th, 2015, he ended our 8-month relationship via text message to my cousin. I was extremely relieved by this, as I found him to be insensitive to the death of my cousin and wanted to run for my life from commitment that would have been a big mistake. We messaged back and forth several times and argued. I attempted to end things on good terms. However, Josh decided to consistently message my cousin and me repeatedly about how horrible I am, then threatening to kill himself, even writing a very creepy song and singing it to manipulate me. I have this song in my text messages on my phone. When he didn't get what he wanted, he became nasty again. He said horrible things to me about me to my cousin over the course of 5 months. On June 21st, 2015, I had to block him on Facebook after he sent nasty messages to me. On July 3rd, 2015, I blocked his phone number from my phone after the last message said, "I will devote my life to make sure you are miserable." He then bombarded my cousin with messages on
A
Facebook.
second on that, have you seen, did she provide that text to you? Have you
There's
seen that
several.
text?
I can hand them.
No, have you seen one that says, I'm gonna devote my life to making you miserable?
I did, Your Honor. I think when I saw it earlier today, I wasn't able to distinguish who sent the text, but it's in here.
I mean, who sent it? She's saying he sent it.
He's saying she sent it. I just am not familiar with their phone number, so I couldn't tell.
Oh.
But I did see that, Your Honor. I mean, there's 30, 40 maybe text messages. I can go back through them if the court would like.
Okay,
I can do that when counsel's. Sorry. On September 25th, 2015, he messaged my cousin repeatedly asking about me, and I finally called him from a blocked number and explained that I want nothing to do with him and that if he continues to bother us, I will contact authorities as this is causing me extreme emotional distress. He disregarded my wishes yet again and messaged my cousin again, calling me names. He persisted to email me. I I responded one last time explaining that if I receive another email from him, I will contact the police. He did not listen, and he emailed me again in October 16th, so about a week and a half before the motion for a temporary order. He threatened suicide to me and my cousin, stating how and when he would kill himself. He called me names, incessantly contacted me with total disregard for my feelings. After I clearly stated over and over again that I wanted nothing to do with him, he's pleading for another chance. I've been grieving the murder of my 20-year-old cousin, which happened right before this breakup, and Josh's complete disregard for my feelings and disrespect to my wishes is causing me extreme emotional distress and anxiety and paranoia. I'm always paranoid and worried he will be outside my work, as that is where we met. He no longer, I think this is obviously over, he no longer works. I don't think that's the case for him any longer, but I'm always looking over my shoulder. I moved recently, he doesn't know where I live, but he does know where several of my family members live. He's clearly mentally unstable, and his obsession won't stop and frightens me to tears and to the point of physical illness. I need help to keep him away
Okay,
from me.
I've probably heard enough.
That's one of the
Let's
reasons
go,
we're
what do you
asking.
wanna say? Well, why would I give him deferred anyway? He has a long criminal history.
That's gonna be the
And if you're
other.
gonna be asking for it, I mean, despite the fact situation, but, you know, as I could, but normally give deferred sentences to people who made a one-time mistake in their life. He has 10 entries and several other convictions for criminal matters, so it'd be abnormal for me to give him a deferred sentence anyway, wouldn't it? I mean, at least to my judgment would be, but you think he should get deferred because it's his first DV?
It is his first TV, Your Honor. There's obviously a mental health issue here. He was not represented by counsel for most of the time that he was in front of judges and also talking to the prosecutor. He made statements essentially to the prosecutor that would make it impossible for us to go to trial. So based on that, we're kind of at a rock and a hard place with what's going on now. He does have a job, however, if he does have a DV conviction, essentially that job is no longer an option.
What is that job?
It's a Army, what's your job?
Well, I'm working on my master's to get with the Army Corps of Engineers. I'm working for the VA right now.
This is obviously a breakup that was not very good. He shouldn't have sent the emails. He's taking responsibility for that. He's going through mental health counseling now. He's back on medication. So I think this was a thing where he was spiraling downwards and he fixated, and now that he is in treatment and that is part of the pretrial agreement is to continue with that treatment. He hasn't had contact since with her. It's over. So that's why we're asking for a deferred sentence.
You a veteran?
No, sir.
Okay. Oh, you said going to treatment, I didn't have veterans deal, but anyway, you're saying the Army Corps of Engineers, wherever you're trying to get your job, would not hire you. They'll hire you with prior DWIs, possession of stolen property, some of this other stuff, but you're saying,
Yeah.
because I
I've
think that one's a
spoken
juvenile.
with the commanding officer of the ship, and that's what he informed me, that the domestic violence would preclude me from getting on my ship.
And there is an email that was sent to prosecutors that I also received that has that information in it as well from his potential employer, so.
I just don't know, one, how much of a distinction maybe there is for them. I certainly can't speak on their behalf. Sounds like you'd be convicted today, it'd be a deferred sentence. Your Honor, I didn't get a chance to really speak too much into it. I'll make this very quick. Our office, and it goes into kind of what counsel was indicating regarding probably the difficulty of presenting a defense at trial. We received myself.
He didn't have any. Okay, even if he made statements to him, I don't see how they'd be admissible. That'd be offer of settlement negotiations. If he was representing himself, talking to the prosecutor, they couldn't use his statements
I
against
wouldn't
him.
plan on using the ones he made to me. The things that were more concerning were the numerous emails he sent regarding suicidal tendencies.
To you? The prosecutor's
Yes.
office?
This is a case where he ordered, we had to bring it in front of the court regarding our concerns for 1077. While I didn't think that there was an issue so much regarding competency, I brought this up initially in front of Judge Langsdor. I felt I had to, just based on the communications. We addressed that with Judge Langsdor. He then asked to order a 1077 on himself. And then, we proceeded to do an out of custody 1077. It came back competent. During that span of time after, again, I received emails, regarding what I would deem some mental health concerns that our office has. So again, based on the victim's wishes, based on criminal history that he has, based on the resources the age in this case, we just don't feel a deferred sentence is appropriate, Your Honor. Yes, you follow the trial.
Okay, when I found you're guilty of the offense, you have a right to speak if there's anything else you want to add. I mean, it's hard to get all the facts without a full trial and all the witnesses here, and you certainly can't do that in every case involving a plea, but she goes on and on about your insensitivity to her having lost some cousin, but he's emailing a different cousin?
Correct, Your Honor. She was
Trying to get
emailing-
that cousin to communicate for him to her or something?
That's my understanding. I've spoken with her on probably 2 different occasions, Your Honor. It's been a while, but to the best of my recollection, he would contact her family members essentially out of way to get a hold of her. I think at one point one of her cousins was friends with him after the breakup. He was still texting that.
Where was the business that you two used to work together at or something?
The state of Washington,
Yes.
at the Department of Social and Health Services. I was a financial coordinator.
What does that mean, a
She was in
screener?
a call center, yeah, basically.
You have a college degree?
Yes.
Yeah, so it's something like 12 plus. Well, it sounds like you're educated and should be able to figure some of this stuff out, but with, I guess I'd be creating certainly a new, some kind of new scheme of things to give a deferred give a deferred sentence to somebody who has a fairly extensive, felonies, but extensive past criminal record. I've just never done that before. You've been charged with like rendering criminal assistance to somebody, because maybe that was so long ago. How old are you? Or
I'm 36,
what's your date of birth?
7/28/80.
Well, I guess that's a juvenile conviction then. You were born in 1980?
Yeah.
I think 2 of them were juvenile, the rest were on.
Oh, so you had possession of stolen property, anyway, rendering criminal assistance, I guess when you were 14, but then you had minor in possession conviction. You had 2 DWI convictions, then a minor in possession, fishing violation of some sort. Several or a couple of different fishing violations. They're serious. A DWI getting amended down with your alcohol problem was what it seems like. You were the respondent must be in this case. That was in this case was harassment. And to me it sounds like he unmercifully stalked her and emailed her to death, and probably weren't charged with more offenses. So that scenario, no, you're not going to get a deferred sentence. I mean, you have rights just like the gentleman earlier this morning. I don't know why he waited 19 years, but anyway, whatever it was. But he came back and got his case eventually dismissed because the law says you can, but they say the waiting periods for a ED matter is 5 years. So for me to, like, say, carve out an exception just so maybe you can get employment doesn't seem like a rational thing to do under the circumstances with your record and the nature of this case. So you did 1 day in jail. You said there was some other supervised release or anything else where he came in or had to do more time, just 1 day total?
I think it's just 1 day total.
That's correct, Your Honor. He turned himself in.
On the bell jump, so there wasn't any extra time. So 1 day, 350, that's not 359, that's all right, but you had 1 day. That'd be 363 suspended. Credit for time served. Are you employed now?
Yes, sir.
Again, it's still you're in the Corps of Engineers doing something with them?
I'm with the VA right now. I'm working on my master's
And
degree.
Okay, you're working at the VA. Well, it's unfortunate, but you gotta switch professions, you have to switch professions. I know there's places, just like they won't let people, you know, work, like schools or volunteers. If you got an assault conviction, you're probably not gonna get a job at the school. Got these kind of some bright line rules. $135 is the filing fee, $43 to court improvement fee, $100 is the domestic violence assessment, $15 DV fee, and fines are all suspended. 2-year bench probation. You're gonna be told and have to sign now that you can't possess any firearms, it'd be a felony. They're gonna be, this,
I think this isn't, yeah, it's not a no contact, it's an anti-harassment, so that can be, that's considered a conditional sentence. I don't think you need to sign anything.
No, it's a protection order.
what now?
Anti-harassment, it's not the same. Yeah, it's under a different statute.
Okay, he's pleading notice, there's a
We
DV.
would ask at the very least order it as a condition of sentence, Your Honor. We would ask the court to issue.
No contact order.
I think they're, are you?
We're not
They're
arguing
talking
the no
about firearms.
contact order, we're talking about the
Oh.
firearms.
Yeah, okay.
Okay, so the
Condition of
five, see,
sentence firearm.
so the 5,
Yes.
okay, the prohibition on the firearm doesn't
Where are you
apply,
going?
because it's an anti-harassment DV, is that what the point is?
Are you going just for her? I think so.
Um,
So I don't think that's a big thing, but we'll see. Was it fun?
Have a mental health, you are going through some sort of treatment now?
Just 'cause I wanted to go. Right.
We'll continue with your mental health eval and comply.
I just looked at first, because aren't there like things that like interact with?
Who's that with?
Go down towers.
Kaiser.
So you have to make sure you get a one that has the.
Is Your Honor ordering him to get another mental health evaluation, or are you just ordering him to?
We didn't actually see the show for that, because.
I guess continued treatment, I just wonder if that Kaiser treatment, they don't do DV treatment.
Like simulation, 3D glasses, and you're.
I mean, I don't know what Kaiser do, have a DV evaluation for all the recommendations, to see if there's,
Too. I actually have been to the Harry Potter movie.
something that they think is needed in addition to the mental health, or if the mental health covers it, you definitely have some sort of
with
a
other people who are not the same.
stalking type
We're just gonna go down to.
behavior in this
That's really the only. I mean, we're
situation.
flying in on Saturday morning, going to Universal. That's really the only thing.
And she absolutely, obviously wants no contact with you at all.
I don't care about Jurassic Park.
So it can't be any contact at all, text, phone, email.
This is
I've also been on it before, because I went there when
Like I say,
was.
it's good, and maybe you've given it up, but I'd
No.
It's like,
strongly suggest the same thing, that you're not contacting her cousins and trying to get them to contact her for you, because that would be a violation too. If
Mr.
there's any
Cuddy,
suspicion that that was happening.
you need to, once you're done
so you're just gonna reset
work,
so
you need to
that
go
you can get it.
across the hall and check it.
Try to do
Okay.
that, across the hall.
Across the hall to administration.
Oh, administration.
And then, do you have you put in it yet? 'Cause if you do, I'll start the regular ones. Yes.
Next case we have is, last name of Dore, Your Honor, would know. I believe this will be a.
What's happening now? Odor? I mean, this is Len Odori?
Odor.
What?
Odor.
Odor. Big O. Hyphen door. Not Dore. We're setting,
So we have November 7th as a readiness, November 9th as a trial date, Your Honor. That's agreeable to both parties.
that's fine, what was the,
Domestic violence court order violation, Your Honor. Looks like they were extra roommates.
That's okay. Just got scheduled this time, and usually we have Tuesday mornings for our trial sitting days, I think, but I don't know. Today's readiness, but she was coming back for some sort of review. Now we're setting up for trial.
Alright, step over here.
Okay.
Hold on one second, sir. Let's, I wanna make sure we've got the gun thing down.
What do you have, ma'am?
I have Austin Holmes.
I understand, but in case you or if you're driving in a car where there's a gun.
He was supposed to be here for readiness?
It was a review, Your Honor. It was going to be, he's working on getting into diversion. I don't know if he had
Okay.
wanted to enter at this point or sounds like there's some complications, but he's not.
Anyway, wasn't a readiness for a jury trial this week, looks. Salt 4 DV. Assume he signed a promise to be here. You see there was a diversion referral in August. So this is his only, the brief that his criminal history is his only charge?
Yes,
And I can wait to the end of the docket if you have no knowledge or calls that says he's coming or anything like that to wait.
I have not spoken with him. I need to head over to the jail to see some clients. He does-
Okay, if by chance he shows up, we'll try to get a hold of you or somebody. What do you think within he was scheduled for 8:30, right? Probably.
So I don't
Close at
don't have
9,
a
he's.
copy of the promise proposal.
Second. Prosecutor? Blair, what did you say? I mean, you want bail jump? Did you say what you wanted to, okay, a bail amount?
I did not.
You wanna indicate it? He was a diversion eligible person, 2,500 enough, or you allow you to add bail jump, or what do you want?
I will move to add bail jump and then I'll bail him out up to you.
Okay. Yes. Since he doesn't have much record, I'll do 2,500 bail jump to be added on. Sure.
Since it was a temp window.
You said they're bringing over one in custody. Is he a jury trial this week? She, whoever it is.
Do I? Is it mine?
I don't know, it's somebody. Jeff says it's not his. I thought it might have been yours, but I'm not sure. Sounds readiness.
We're ready on Wilson.
What is it, Wilson?
Wilson, it looks like this is a diversion entry for 2 cause numbers.
Sounds readiness.
So Lisa Wilson?
Oh, Colin
Oh, ma'am, you said 2? This is listed twice. I just have a entity 238. You said there's 2 cause numbers?
Yes, there's a 6E0562428.
Do you have that,
Here's the case.
Nancy? You don't have it? I have,
It's the weapon, the injury.
They look almost identical. We have that issue.
She's.
One's in,
056,
To get
one ends in,
2428, I,
238 and a 428.
238, right, 428. Well, I guess I can't do both of them. What are the two charges?
One's assault for, the other one's a violation, no contact.
So 428 being the bigger number? No. Which one came first? Either way.
Another one. We were trying to figure that out. It's right here. Yeah, cause these usually get issued under 10.14, aren't they? Several.
Okay, Ms. Wilson.
Yeah.
A stay means you're not gonna be prosecuted.
When I read this.
As long as you obey all the conditions of the stay, eventually your charge gets dismissed.
Right. Doesn't.
But to do that, you have to waive speedy trial, cause your stay is for, let's say here's 1 year. It's for 1 year.
So I guess we just go to October
We do
third,
get a-
2017 on the waiver.
Get DNA.
Yes, Your Honor.
Yeah, you get the DNA. It's kind of a weird.
When we need to
So you're saying October 3, 2017.
Yes, Your Honor. That's his client,
It's my in custody.
Where?
Yes, I'm sorry.
State any information as to the victim's wishes with no contact order.
Why is there a waiver of counsel in there?
They do that because the defendant meets with the prosecutor's office in my absence. Violations filed, or she has counsel.
Yeah, so.
Your Honor, we don't have that any information.
Let me, write it down so we're on the same page.
Is it Mondays that the motions should be?
They can do Mondays or Tuesdays.
Mondays or Tuesdays?
What are we asking about now?
I was asking when motions to rescind no contact.
I'm gonna pass this down. Why don't you have her or you at least initial the commencement date of the waiver of speedy trial? They fill that in.
Do you have a number by chance for her? I can just. I asked him, he said 4 or 5. Spoken here.
So the purpose of having that commencement date out there
What
means
do you want me to do?
in case you messed up on like the 11th month of your 12-month stay.
Judge just asked.
Happen, Your Honor.
Good. Who'd you have contact with, or who's this with?
My daughter.
What, oh, not a, because it's not a, obviously a boyfriend or
No.
husband relationship, so you allege, how old's your daughter?
22, 23,
It's
23.
23rd.
So have we taken care of the no contact order, or is it out?
Well, we don't have the
Conditions?
information on it, so I'll have to bring it back in.
Well, that's what you're asking about in this
Yeah.
case.
This is it, right?
Unless we can drop it now.
Well, I can't do that without her being here to say she didn't want it unless the prosecutor wanted to do it that way. If she, I don't know if she
I'm sorry, Your Honor. I
was
need-
contacted.
Yeah, so I'll cite it on, talk to her, cite it on. Now that the case is kind of disposed, I'll talk to her about it.
Oh, you missed the
If she doesn't
original.
want it, I'll bring it back.
We usually thought the advocate
Dang it.
talked to her. She doesn't live with you, right?
Here's what we can
No,
do.
we were all living together and I was,
It came to
no,
me.
removed.
I'll just do it.
You were
From the
in-
home, yeah, and I have a new place. I have an apartment with my husband. But my mom, she lives with my mom.
This is retained.
Who's 74. She's got,
The daughter lives with the mom.
yeah, she lives with my mom.
Right.
And so I can't see my mom. I can't care to my mom's needs because I can't go there.
Yeah, it's always, they've been worked out earlier, if the daughter actually wants to see you. Yeah, you could only go there when the daughter isn't there, or maybe not at all, if it's
I
a
was
stay
under the
with the
impression I
daughter's
cannot go there at
residence.
all.
Yeah, if it's a prohibition from a residence, yeah. Anyway, as your attorney will contact her, if she tries to contact you, you can just say you can't talk to her.
Yeah.
With a no contact order drop, whatever.
Found that out the hard way.
I guess, yeah, if you got a second no contact.
Yeah,
order
with the
already.
violation, yeah.
So need indications, did she come in? I don't remember.
I don't think she's ever been here on my watch, so we'll
My-
contact her and we'll file a motion if
My
we
daughter?
believe it. She hasn't made a statement,
I know.
so we'll see what she has to say.
Right.
Thank you so much.
All right,
Okay,
you're
well,
done.
hopefully, if she wants to drop, hopefully
You
we get
already
that
did?
Oh,
done.
perfect. All right, have a good day.
And then just for the record, no more supervised release on Staples.
Right, supervised release would stop.
Perfect. Awesome.
All right,
Thank you
Ms.
so
Boss.
much.
Done?
I got one more. I got Lawrence Mohamedou.
Hold on. What are we doing?
Your Honor, this is on for review of the 1077. Mr. Terry was appointed at the hearing that I had cited on September 13th. And my understanding is that Mr. Lombardo hasn't had a chance to schedule an appointment and meet with Western State. So I believe this would need to be set over to facilitate that.
Okay.
Well, Your Honor, my questions are, has the court already entered the findings and order regarding the 1077 at this point? Okay. And so another thing is the interview cannot be held at Vancouver Defenders due to the conflict. So I'll try to see if they can do it in my office, which is right down the street. If not, we'll have to schedule them there. That's all I have. So if we could have 8 weeks, I think a good date would be.
I'd rather not waive any time, Your Honor. I'd rather just go get this done and then set the trial date within 30 days.
Defendant does not, Mr. Mohamedou does not believe that the evaluation is necessary. Well, Your Honor ordered it, so I don't know.
And what were the findings for the order as to why you ordered that, Your Honor? I didn't see the findings as to why you ordered that.
I think it was by everybody agreed.
Everybody agreed? I fired my attorney and then
Except
2
you,
minutes
maybe,
later,
yeah.
you said that I needed a mental evaluation, and then you appointed another attorney, if that refreshes your mind. So I don't quite understand why you ordered that 1077 hearing.
Your Honor, it was based on a conversation that you had with the defendant on the record.
I don't remember the exact details, but I don't know if it had to do with you talking about mind control or,
Rendering and genes and stuff.
yeah, but,
It was based on a book that I'm writing on Facebook, and I didn't get a chance to put that out, Your Honor. So, you cut me off and ordered me to have a 1077 hearing prior to even me getting to explain my circumstances in the case. And it was all due to Facebook, and it appears that, Your Honor, that,
I can't remember if you were talking about the CIA was doing mind control on you or something like that, but I could be off a little bit. That sound familiar?
I believe you're off, because I don't think I was talking about CIA and mind control, was I?
Yes, you were.
That hearing? Well, okay,
Yeah.
well,
We
I'm
had to-
very familiar
that's
with
okay,
that
no, if we had to
MK.
go back and play that, you can order it up to tape and listen to it. Did you?
Right, but
your
I
attorney
just want
think?
you to enter findings as to why you had me go through that. Because I know about the
Wanna-
MK Ultra project, and it's a mind control project, and I'm writing a book on it. Is that why you ordered it?
I think you said, maybe some of it was true. I can't remember. I think you said you were like you were a former Navy SEAL or something like that too, and that you were.
Yeah, I was a Navy SEAL, and I was in pararescue, and I've had top secret security clearances through the Department of Defense. I don't think that makes me mentally ill. I have post-traumatic stress.
Your Honor, he said that they changed his genes, they were rendering him, and they wanted him for his genes, and then he compared himself to Snowden, and he ordered it.
Yeah, I think you're, making some statements that might lead a reasonable person to think you had some paranoia. Maybe I'm wrong.
I have a top secret security clearance and I know a lot about the federal government.
You
Your
still
Honor.
have that top secret security
Yes,
clearance?
I've always bound by that, you know that.
I guess you may always be bound by it, but I didn't know if you still have it. I mean, sometimes they take away the top secret
Mine hasn't
security
been taken away, Your Honor.
clearances once you're no longer in the service.
Mine hasn't been taken over. And so I would ask
Okay.
you to enter findings as to why there's a 1077 hearing today, as we speak.
That's not required under the law. Okay, also, something your attorney was saying you want trial set within, I can't set a trial until you're determined to be.
I do not want to waive my speedy trial. Her witness has been unavailable for over 585 days to be interviewed, Your Honor. Over 585 days, and their witness we haven't been able to interview her. I've given every statement as to what happened that day. I've given it to opposing counsel, and I'd like her to read that statement into the record so that we can be done with this. Her witness is a multi-decade user of opiates. And that's the witness they're gonna bring and testify against me?
You're talking about your wife?
Yes. She tried to have me
Okay,
killed
slow down.
so that she can collect the life insurance policy and $12,000 a month. She attempted to have me murdered, Your Honor. Attempted to have me run over a cliff, where I spent a month in the hospital and 2 months in a nursing home. She did that. Officer Torres tried to render me the day you
slow down.
released
Calm down.
the same day that you released my counsel without me being here was the day I was supposed to be rendered by Officer Torres' brother in Pendleton, Oregon. He's the same person that shot somebody 11 times in Torres versus Wilkinson. I brought that case to you before, but you didn't judicially recognize it and said this isn't before this court. I'm going to testify to the fact of the training that I've had and the training that Officer Torres had.
Do you think the 1077 should be withdrawn?
I'm not in a position to speak to that right now.
Okay. We're going to continue with that. If it turns out you're incompetent, then the charges may be dismissed. I don't recall, I can't say, and I've heard maybe 500 to 1,000 cases.
Okay.
Literally,
Okay.
since the last time I talked to you. I don't know what you're talking about. You're talking about an officer involved in your case, Torres shooting people in some lawsuit? I have no idea what you're talking about.
Torres versus Wilkinson is a federal, it came from the Ninth Circuit Court where he shot somebody 11 times in the
You're
course
talking
of
about
doing
an
his
officer- Talking
job.
about an officer who investigated your investigation?
He's the arresting officer, Your Honor.
For the record, Your Honor, the victim is present. If you want to hear her. I think we're just doing a 1077 determination. So.
Yeah, we're just in 1077, there is a no contact order. Okay, and I don't really think I need to make much of a record, but what I do recall is that you were present in court, I mean, you've appeared most of the time, or maybe all the time, with your attorney, and I think you're talking a lot about a divorce case. Your attorney wanted to withdraw from the case, and he did, that was Mr. McDonald, and he wanted to give all your information reports to your attorney, and you refused to allow those reports to be released to him, so that may have slowed things down a little bit. I can't answer
So
your
what
other
happened-
questions about what you're talking about, me not considering something about some federal case involving an officer, and I don't even know if it has anything to do with this case.
In the interim, Ms. Kaufman was appointed, and she was only on the case for a few days before he threatened her, and she withdrew. So we never had a chance to
Objection, Your
send
Honor,
her-
I never threatened Miss Kaufman at all.
That's an
And she's
allegation. I don't know if you
testifying.
are, I don't know, I don't know.
I'm sorry?
I wasn't there, I'm just.
Yeah,
we got-
she's
we got-
testifying for
we
Ms.
got you-
Kaufman.
We got some new,
And-
new counsel.
I would like to bring them back and have them testify as to why they withdrew, not threatening.
Well, I'm not sure
So,
that's,
Your Honor, I'm just saying, we never sent her any discovery, so, but we can send it to Mr. Taylor. And her withdrawal.
somebody
hearing
must have
was-
perceived it that, because they had to shut down their office, but whatever. I guess you were never charged on that, so I guess it didn't amount to,
It's pending in the county PA's
still
office.
pending? Been
You know
pending a
what?
long time.
The Clark County PA's office
There's
is
a
reviewing
charge?
it.
There's
They're
a charge?
reviewing a police report.
Okay. Well, before I leave today, I'd like to set up a date where we can interview Shalane and Officer Torres, and a date where she's gonna provide all this discovery that I've asked for over the last couple of months that I've
Okay,
been
your
representing.
attorney, your attorney does that for you.
My assistant runs my calendar, she'll set up the interviews, and we'll get the discovery, I imagine, through
I don't wanna waive my,
the normal process. You're not waiving anything today.
I don't wanna waive my access to a speedy trial. I'd like this done within 30 days, Your Honor. How can we make that happen?
We can't.
We can't make that happen within 30 days.
No, just because the way things have happened, where it's alleged, I'm not saying it did happen, but alleged that you had some serious problems with your previous counsel, they perceived those.
He
to be-
couldn't interview
I
them-
talked for a
them
second,
for
you
a
asked me
year
a
and a half.
question, then we just quit it, we're done then. If you don't wanna listen, I won't talk.
I would
If you wanna keep
appreciate-
interrupting me, then
I
we're not gonna get there.
apologize.
You asked me a question, I don't know if I'm gonna get through to you, probably won't, but part of the delay is because of your behavior, where you've allegedly threatened your counsel, didn't cooperate with your first attorney or your attorney on the divorce case, who wanted to give out all the information to the other side, and you said no, you wouldn't sign any releases. And again, it's alleged that you made some threatening type statements to the Vancouver defenders, so they had to actually shut down their office for a whole day. Nobody could enter, call the police and so forth. So that's delayed things for us to give you a new attorney. Now, until we find out you're competent, I can't set it for trial. So we have to have you evaluated by Western State Hospital. If you're found to be incompetent, maybe the charges.
What was your
then the charges-
ruling
Then
as
the
to-
charges get dismissed. That's all I told, well, my ruling is, you were talking about mind control, the CIA.
About a book that I was writing, right? So you're gonna have me go be evaluated because of a book that I was writing?
No, not
Okay.
totally.
Not totally.
The evaluation will probably take,
I don't know if you're writing a book. I don't even really know, to be honest, maybe.
prosecutor won't be present.
But you can provide all that information to Western State if you really are or were a Navy SEAL, and if you really have this top security clearance. You know, you may wanna show that stuff. I mean, I can be wrong or fool. I mean, I once had a guy who I thought was pulling my leg when he said he was an astronaut, but we Googled him, he actually was an astronaut years ago, but he since had fell on hard times and was a die-hard alcoholic. So I was kinda surprised, and he kept on telling me he was a real astronaut, but he really was. But
Well, I can assure you, I
20
was a
years
Navy
ago.
SEAL and I was a pararescueman and I was a smoke jumper, and I can assure you that,
Okay, maybe you
that our
weren't.
witness is a drug addict, or has
I don't
been.
know. I don't, and I'm obviously.
Are you gonna stipulate to that?
I'm
that
not,
she used
no,
drugs
sir,
up to
don't
2012?
talk to
It's in
her.
her affidavit in the divorce. Okay.
No, I don't know, maybe Brad Pitt used drugs too, I don't know, you know, I don't know all the stuff they really do, but that doesn't necessarily mean if they use drugs once, that you didn't assault them, or you didn't do whatever you were supposed to have alleged to have done in this case.
So,
I
as-
don't even remember what the charges are.
As far as discovery,
Assault for and
is she gonna,
Assault for?
is she
And
gonna
harassment.
provide discovery? Are we gonna have a decent time for her to answer all the questions that have been asked, or do
Yes.
we
Your
have to start
attorney,
the?
your attorney
Yes,
takes care of all
If I
that.
don't get the discovery or the interviews,
But
I can
what
file
is-
a
I'm
motion,
sorry.
I believe.
We
Day
have a
one
trial
for
within
me.
a trial, it's
That
gonna
doesn't
set them
work,
up.
then-
What is your name? Who's, just a second. Hang tough here for a second, sir.
I'm sorry?
Just stand there for a second. if
Yes,
you
Your
want.
Honor.
Who is
Her name's
his
Shalane.
ex-wife?
I've got a case in
Okay.
Lewis County tomorrow at 10:30.
Boy, we need
We've kind of already
security here.
set the case over, so I'm not
At
sure.
one.
Ma'am,
Where's it at in the process?
I have a note here, today is not the trial. It said you're here
Every case, every.
and you wanted to speak.
Yes, I do. Your Honor, everything that Mr. Lamadou is saying is untrue. He has threatened my attorney, has threatened my father, he's threatened his mother. There's all sorts of restraining orders out on him, including my former attorney, who has a restraining order against him as well. He needs to be
Okay,
evaluated.
just a second, yeah, he is gonna be evaluated without, I don't want you to jeopardize your safety in any way, and I know you're frustrated and so forth. I know he did have, Mr. McDonald, I don't know who your attorney is. You're saying your attorney has no contact orders out against him?
It's because I saw the last hearing
talk to
on a
her, get back
DVD
to
and I
the
saw
office,
everything
but
that he was
I
saying,
think
which
I'm
was
gonna be here
untrue.
tomorrow, so.
I was available for all the interviews. His counsel counseled, and I was ready for the 18th. I'm sorry, I'm shaking because
No, I understand, I mean, yeah, calm,
he makes me nervous just
it's
being.
easy for me to say calm down, but, you know, wanna make sure you're safe.
I've been through so much. He's harassed me on Facebook. He's harassed
Actually, there's a real quick couple things. You were married to him for how long?
18 years.
Okay. And like you just said, you think it's in his best interest to have,
Yes, I do.
that Western State Hospital
His mother
eval.
thinks so too, yes.
Right. Did you know, was he actually in the service?
He he was never a Navy SEAL. He's never seen combat or any kind of missions. Have you, Mr. Lamadou?
Don't talk to him. That's not gonna work.
And
So you're, at least you were married to him, but you don't, just a second, but you don't think he really was a Navy SEAL?
No, I have evidence.
Or
to
really
prove that.
has his top security clearance that he talks about?
He's never
Oh.
been an FBI agent, and he's not Your Honor.
Hmm.
And I can prove it.
Well, I'm not sure it's something you have to prove. I'm just saying, if what he says was correct, I assume he can somehow provide that information to the Western State
I will, Your Honor.
Hospital
I'll provide my
evaluator.
DD 214, it's on my DD 214. And I
Okay.
was a Navy
Then
SEAL.
you
I
can
don't know
provide,
what.
today's not the time for me to
Alright.
decide those issues, but obviously if you're not, then we gotta figure out why you think you were.
He went through training, Your Honor, but he never went into any missions to get PTSD. He's claiming PTSD because
People can
his
have
friends-
PTSD without even having to serve in the service, and for shocking
But his
deaths or
friends
whatever.
taught him how to scam the system. And there's 2 other men exactly like him. They're doing I was married to him. I was part of it. I saw everything that he did.
Hmm.
So,
Okay, we're going
I'm
kinda
saying
beyond probably what needs to go beyond, but,
I'm just, I don't care about that. I just want Your Honor to
no,
know
but I say,
that,
I don't think you,
that a lot of what he's
you're
saying,
suggesting he's faking insanity or faking the mental illness, so I don't,
he's getting paid really well for it, Your Honor.
My death is worth a lot of money to her, Your Honor.
This is untrue.
not true, not if you're divorced, she gets nothing.
Yeah,
Okay, but
exactly.
anyway, shh, okay, quiet.
Exactly.
Anyway, I
She
appreciate
gets
you
nothing.
coming, and I don't want you to feel uncomfortable. There is a I'm sure, right? There is a no contact order there. He can't email you, call you, anything like that, and, I guess you're still going through the dissolution with whatever attorney you have,
Yes.
and he doesn't have
Are we
one.
gonna subpoena the records from Mike Rowe's phone?
Okay, thank you for coming, and I guess you'll be notified. The way the system works, so I would suspect there won't be a trial for several months, maybe not even this year. Probably not this year.
Okay.
Because they have to make special arrangements because of the problem you had with the other attorneys to find a place to evaluate you. I don't think they even have an office here yet in Clark County
They don't.
themselves.
They were using the conference room at Vancouver Defenders.
Right.
They have a conference room. It's down the street also, but
Yeah.
she can't come down
So
there when
anyway.
they're done.
They'll have the evaluation, they'll send us the report, how much we gotta set this over? Or how much?
We already did.
We set it to
Oh.
November 14th. It gives me
Sorry.
8 weeks to get this done.
Okay, then he's got his dates. You're excused, I'm gonna give you time to leave, and then he's gonna stick around here for a while,
I'm okay with it. Thank you.
okay?
Okay, thank you, Your Honor. I think that concludes our hearing.
Okay, you got your date?
I'm gonna do my trial setting and take
Got
over.
your date, you got any other questions?
Good.
Nobody's helping me arrange, I haven't had any visitation with my kids, and nobody's helping me arrange that.
That's something that you're,
This court doesn't have jurisdiction.
Right.
that's your
I'm
civil.
just letting you know.
I know, but that's your civil attorney that you fired, your divorce attorney, not me. I mean, I don't have anything to do with that one.
Thank you,
Ready
Your
for
Honor.
the next one, Your Honor?
Good job.
Elizabeth Mall, 6Z0811616.
Your Honor, Ms. Mall at this time is on for readiness, however, we have reached an agreement with the prosecutor. We're asking to set the matter over 3 weeks. I've advised her she has a right to speedy trial, which she's willing to waive.
How's your honeymoon?
It's a matter of providing paperwork to counsel and to.
I'm sorry, one more time, you said we're setting it over for what?
3 weeks, counsel, do you have a date that's good for you?
Oh, the reason is,
Just for a review,
what?
Your Honor.
We just reached an agreement this morning that if she provides paperwork regarding her mental health evaluations and her current treatment and her classes, what's that?
Do we need to set a trial set?
No.
okay, we just, I got you. So it was on for trial, we're striking the trial and setting it back for a review.
And she's waiving speedy trial.
Thank you. Effective or return to the next day, 3 weeks?
Yes.
We use that as commencement date, okay.
Come on
Thank
up here and
you.
join us. Yes,
Okay, sorry, that all this
You're part of this.
matter is taken care of.
What's good for you?
Tuesday morning.
Tuesday morning,
This
3
is
weeks from
Monday's
today.
getting pretty good today. You can keep them like this.
And we get transport here.
Yeah.
That's fine, thank you.
So Tuesday, October 25th at 8:30, your return for maybe disposition.
And you give me that paperwork. Okay, thank you, thank you.
ZO638292.
Last name is B-U-I? Bowie? Boo? How do you say it? Bowie. Okay. And are you
Ms. Bowie
representing
is pro
yourself?
se.
Pro se.
She's pro se, Your Honor.
No, okay, I paid you some rent.
We had a pretty
Yeah, for a
extensive
half hour at
discussion
least.
out into the hall about some of the options for her case, one of which was to enter diversion. The other, at least from our perspective, was to set it for trial. Ms. Bowie has signed a waiver of speedy trial that commences today.
Give me the names.
She's
I'll come
decided
back.
that she'd like to set
I'll
the
be
matter
in
for
D-bar.
trial. We have 90 days to do that, as she's out of custody. We've chosen December 2nd, 2016 as the trial date. The Monday before that is November 28th, 2016. I don't know if you got court that day? That's the Monday after Thanksgiving? Is that, we do?
It
Okay.
would.
And that's what we would like to do.
Okay.
Correct? There is, so the trial date is set for the Friday, and then the Monday before, we have a hearing to make sure that we're both ready to go, actually go to trial on that Friday. It's just a double check hearing, basically.
Your Honor? Can't you leave?
Yes.
Do anything, I promise. Thank you, Your Honor.
Those dates work for the court?
Who's the,
Yep.
Is that yes, Your Honor?
Yes.
Okay. Could you sign right there, Ms. Bowie, and this just is your promise to return on these two dates. They're mandatory appearances.
What they did
The Monday one will be fairly brief. It'll be somewhat like today, but since we've already talked issues over, it'll be fairly brief. And then Friday should be all day. That's
Cover that once I sign it. So we had a brief chat before. I can't remember. What is your job again?
I'm a billing manager at the electric company.
A billing manager? Is that what you said? But you don't qualify for a court-appointed attorney? You're screened. They say you make too much. Did they say if you even qualified for what's called the near indigent list, or do you know what I'm talking about?
Yeah, I went after the court and I made too much for that.
You make too much for that. Well, it's generally not advisable for people to represent themselves, especially through jury trials, but you do have a constitutional right to do that, but you're saying you can't borrow or come up with funds or anything to get an attorney, I guess. Is that right? Pardon?
You got the good news.
What? You got the puppy?
Well, I'm not sure, and the guidelines are all
You must be, you were like 17.
dead on, but they're saying per what you make, you should be able to, I guess.
I'm going with this one.
What's the charge?
Nothing else black.
For malicious mischief.
This one is red. The other one's black. It's dark. I told her she could, I said those are the two favorite colors I had anyways.
Well, if nothing's changed since the last time, I guess there's no need for me to have you reevaluate him. You haven't had a decrease in pay or anything like that that would increase your likelihood of qualifying for an attorney. So we have,
You would like to know how to
so Monday again, November 28th.
And
We set the
email
jury for Friday.
with children only. So it'll be from on vacation. Did you see my last presentation?
Their guidelines are what seems to be good on that day, because I've obviously never done this before, so I don't know how it.
We cover, right, well, unless you wanted to, you want to have a jury trial, right?
Yes.
Okay. You can have a judge trial, but you'll get a jury trial and, I guess, I don't know. Gonna have to take out, you can come down here and watch a jury trial and learn through watching, but I'll tutor you to some extent, though that's not my role, but at least I'll explain to you, you know, how you pick jurors and how they line up and how it all goes. If you want witnesses, subpoenaed, you're gonna have to, you know, get them to come in. I don't know if you have witnesses, but people to testify on your behalf.
They tell you or?
That's right. I think you told me now.
So, I guess
I was
you
not there.
continue to negotiate with the prosecutor. Or you go figure out a way to hire an attorney. That's why I was asking if by chance you qualify for the near indigent list, cause those attorneys I think are, $450 or something like that would represent you. So look at your paperwork, but I guess you're saying you didn't qualify. What's your net a month?
I make before,
What's your net means after taxes, your take home. Seem like maybe you'd qualify for what?
We're not actually set up.
Well, you have dependents, what? Okay, step over there and sign your paper. Oh, God, excuse me, I guess you got it in your hand.
It's not set for trial.
Okay, come back then.
But she's on, I mean, obviously I'd rather not piecemeal them, but
Jeremiah?
I don't think I could confirm. But yeah, she's on board, I mean, it's gonna blow up. I don't
We're
know
gonna do a
what-
change of plea apparently?
Yes, Your Honor. It'll be plea to counts 3 and 4. Count 3 is being reduced to non-domestic violence. 4 is bail jump.
Some changes here. So, what is, I'm missing? AYD, what were those?
Do you want to
Oh, it's
set the
A4.
no-
So 2 assault 4s are dismissed.
Yes.
In count 3, malicious mischief DV becomes malicious mischief non-DV. And then he's admitting to a bail jump, is that correct?
Correct. It's a little curveball.
I think you got a pretty good plea bargain, but maybe that's all you did, I don't know. Certainly the more serious ones are being dropped here. Mr. Tracy, let me make a note of that. While I do that, who are the alleged victims, or whose property did he damage? Why is he getting dropped from DV?
It was an argument between him and his girlfriend. So there's some damage to the walls of their shared.
So it's a shared residence? Is his girlfriend Veronica?
Yes.
But initially, he was charged with 2 counts of assault on her on 2 different days, on a January date and a February date, apparently.
We had interviews with her. She recanted pretty seriously, and her testimony would have been favorable.
Hmm. Just a second. And why do you miss court?
My client works as a truck driver, and he wasn't able to make it on time for the court date. I believe he showed up in the afternoon.
Okay.
What was the question? Was that the judge's question or your question? Your Honor, this is something that, it's been a little while since I've done the interview. But I do recall that the interview wasn't so much as, I wouldn't describe it as recanting. I know with the malicious mischief, there was never any observations or anything. It was actually a fairly large window of time between when she had last seen the studio / apartment to when she came back. Regarding the assault.
Excuse me, she wasn't there when he supposedly damaged it?
Correct, Your
What
Honor.
you're saying?
That's what I remember from the assault. There was also something with malicious mischief. It was also something, and it was the one where it was the allegation of I believe it was the throw, whether or not it was actually intentional. I do think that regarding the first assault, this is, again, it's been a while, but my recollection serves me correctly, that there was a decent, on one of the assaults, the malicious mischief was not observed. The other assault.
What did he do? I mean, he damaged a wall and
Punched off.
As he's mad, I'm sure why he'd break something in his own apartment or own studio. It's his own place too, right?
Yeah, correct. They
That's
were
the
both living
allegation.
there, Your Honor. Punched a hole in the wall. One of the assaults, and I think this was the one that was if I remember correctly, I can certainly review the notes, but it was an allegation that he grabbed her arm and tossed her. I think it was intentional trip. The other one I think was a little bit better. That was just yeah, this is from January 2015. So the witness's ability to recall was somewhat limited. I think the interview had occurred about 17 months, 15, 16 months since the incident.
Okay. Okay, I'm gonna make 4 entries. So the bottom line again is as stated, counts 1 and 2 are dismissed. Amended count 3 to malicious mischief non-DV. And he's gonna plead to count 4, which is the bail jump that occurred on August 23. The malicious mischief, I guess, was February 2nd. So you went over this with your attorney and understand what their recommendation is, sir?
Yes.
I've already made those amendments per the plea bargain. 35 years of age, completed the 12th grade of school. Mr. Carrasco as your attorney, given up all the rights listed in paragraph 5, A through F. You said you've read and understand those rights, correct?
Yes.
Okay. Pleading guilty of malicious mischief 3 and bail jump, which says in the city of Vancouver on January 26, you knowingly maliciously damaged property. I think we got those dates wrong. At least, I'm not saying necessarily wrong, but it doesn't coincide with the charging document.
I may have put 2016 instead of 15 or
No, but the charging document says February 2nd.
It should be
Malicious
February.
mischief.
Then we can-
What? It should be February, or it should be January?
It should be February 2nd, 2000.
February 2nd, 2000.
On the.
I'll change that, okay. So,
I was going off the assault.
yeah, I think so. Well, yeah, maybe we're close enough on or about, no. And then the other one, the bail jump, though, that is right, that was August 23, 2016. Failed to appear on a mandatory court appearance, having been given a promise to appear. That was you're out of town working or something, your attorney said? You're
Yeah.
late, got
Yeah,
there in the morning?
truck trouble in Spokane. By the time I got here, it was way too late.
Is the, I don't know her name already, is Veronica in the courtroom? She came in since this stuff started and got the no contact order dropped, if you said she recant, or
So I'm
gave
not
different
sure if there's
versions,
ever
or
an issue, because this is
was
a-
one out?
There was never one issued, Your Honor.
Well, there's never one issue, even on assault?
It's,
Go ahead, somebody.
I think it's just because this is again a case that the incident date was January 2015. It was almost a year, not longer, it was like about 14 months since between the incident when he first appeared in front of the court, they were living together.
Okay, but anyways, so you're saying this is a year-old cold charge or something? I'm not following
It's
something.
summons, but I don't believe my client knew about it when it was first summoned.
Yeah, I didn't.
Oh,
So he came to me
okay.
when he found out the
I see.
case, but by that time it's been over a year and they've been living together.
Yeah, first appearance
I
was April
gotcha, okay,
2016.
whatever. Yes, there is, so again, there is no contact order out there to resolve, or get rid of. Okay, let's cover the recommendations. He did 4 days. So what it looks
Speaking of my
like here.
client, actually, the state say he's done 2 days, but that could include time in transport when he was picked up. He was picked up in Spokane most recently. Tacoma?
Seattle, yeah.
Seattle area, then it was on the chain all week, so anywhere between 4 and 8 is agreeable. The point is that the recommendation is credit for time served at this point, because he's been in custody a couple times also.
Okay, retained case?
Yes, sir.
Well, if you don't know the exact number and he has no objection to me possibly give him less, I mean, if I give him more and he hasn't served it, then I guess he should go back in. We'll do 4 on each one, concurrent with each other. Credit for time served. So on the first one of the malicious mischief, I guess before sentence, is there anything else that the city, or, city wanted to say before I sentenced?
No, Your Honor.
So 4 days, 360 suspended, on the malicious mischief. 4 days, 86 suspended on the bail jump. And, all fines suspended on the malicious mischief. You guys still live in that place?
Yeah.
It's a rental?
Mhm.
So have you taken care of the, I guess you have to do that for the landlord. Have you taken care of the hole or patched it, whatever?
Yeah.
Okay.
It's been done a long time ago.
How'd that happen?
The hole?
Yeah.
I punched the wall.
'Cause you're mad?
Yeah, I broke my hand.
Oh,
Yeah, I hit a 2x4.
that hurt.
Yeah, I couldn't.
Didn't work or drive for a while.
Yeah, I play guitar too, so my hand's like never gonna be the same ever again.
That'll be a
Can't play the guitar like I used to play.
lifetime memory. Okay, again, all $1,000 all suspended, I guess, on the malicious mischief is what it says, and $100 fine on the bail jump with 900 suspended. $135 is the court filing fee for the city. $43 is the court improvement fee. $100 warrant fee. That takes care of, I guess, all the mandatory type of fines. Have an aggression control level 2 workshop will be your only requirement, along with the 2-year bench.
Your Honor, may my client have at least 6 months to pay those fines and fees?
Yes.
Mr. Zavala Hedoza?
Is he on for?
He's on for readiness, Your Honor, and it's a little confusing. The one for
They find him, what'd you say his last name is? Vala, with a V? Oh, S, I mean a Z.
Z,
Zala.
Z-A-V-A-L-A.
You have 2 numbers here.
Oh, I'll get it.
144280 is the original assault 4. That is set for trial on Wednesday. And then there are 2 no contact order violations under the 6 Z clause, which were also set for trial on Wednesday. However, these cases were never joined. It's my understanding that counsel would like to go forward with the assault 4 case on Wednesday. The additional wrinkle is that my client has a felony matter pending that I have advised him that it would be in his best interest to wait for a global resolution, which is not here yet. He has instructed me that he doesn't care and he wants to go to trial on Wednesday. So if that's correct.
That was just what.
Do you want to go to trial on
Right.
Wednesday, or do you want to give it a chance to get worked out? And this one's on
What's
the
his
record.
superior court charge?
It's just another attorney's helping me with that, and I'm kind of confused on what each one want to
No,
do.
no, we're not confused at all.
Well, I am.
He's not
Oh,
getting
just
what he
second.
wants. You ready?
Well, I guess I was gonna ask, maybe you didn't know, is the other one a mandatory prison? Maybe not.
No, but they are immigration matters that are dispositive. It's not
But there's
necessarily
immigration issues
time,
too.
it's, So I've told him he's better off waiting but he has expressed frustration and he's compliant and I'm ready to go, so we can go. If that's what he wants to do.
Well, I feel like.
Do you wanna have all of them tried on Wednesday?
What do you mean, all of them?
The assault 4 and the 2 no contact order violations.
Well, no, I do want to wait so that they can, give me a global if that's, that was an option, but I feel like, Brandy Jeffers helping me on the other case, and she told me that she needed these cases,
That's not true. They have a global offer that she's not recommending you sign. That's what you told me,
Yes,
right?
yes, that's true.
Okay, so. So they have not reached a resolution, which is understandable, given the consequences. It's got nothing to do with communication.
So then we will wait.
Final answer?
Yes.
Okay. Your Honor, can we continue the matter in order for them to resolve this felony? This is not a matter that should go to trial, to be quite frank.
No objections from the city. I anticipated that this likely would be a set over to, again, continued discussions on a global, as well as I knew that there was a felony that's going out. The only thing I would ask is two things. I think we would need a speedy trial waiver. The second thing is if council, do you want to just set these for trial dates? And if so, do you want to set both for trial dates?
I would like to set them both for trial dates. I anticipate a motion to consolidate next time, and so if we set them for the same day, that would be.
And I assume, related, that the no contact order originates out of the same
I
assault.
believe that jail calls.
Correct. Yeah, it's jail calls. So I have, and council, I don't know if your client.
Something at the end of the 60-day period from today.
Yeah, that's.
Yeah, whatever you want. He's available.
We could do the 30th.
That's fine.
I've got, that is open. And then, certainly, if something's reached, we can decide.
Absolutely.
I'm sorry, what's the readiness date? The 28th of November. I think we will.
He understands he has a right to speedy trial on both matters. 60 days that he's willing to waive that right in order to facilitate a goal.
I just.
All right. So I'll let her know. Those are your next questions. You don't want to sign it? Okay, well, we sign it. Don't hold me hostage while you do that. Do I remember the no contact order?
No, is there anything we can do?
Is there no contact order? Is there a motion by?
I don't think,
affected
she's
party?
here, but there's no motion.
Does she want to address that issue?
I couldn't gauge, she's out in the hall, I can certainly.
I asked her, but she just wanted to know if she had to speak.
Yeah, that's not what she had said to me. And just while we're figuring that out, council, waiving commencing today. Oh, and just so council, you're aware, while we're checking, I believe the no contact order was modified actually last time on, I'm just trying to get the date, on the 9th of September, and it was to allow for text, phone, and digital contact.
Are you asking for personal
That's
contact?
fine, no, that's fine, I'm here anyway, so.
Okay. Okay, that's all we have then. Thank you, Your Honor.
Thank you. Thank you, council.
Thank you.
Ms. Garcia.
Oops. I filled on the Monday, Wednesday. And this is?
This is Ms. Teresa Garcia, Your Honor. She's on for a motion to modify or rescind domestic violence no contact order
Okay. With?
with her ex-husband. Husband,
married.
Is that
ex-to-be,
one, what's his name?
Lane Boucher.
So he didn't fill out I got some up here, but I don't see any people in the courtroom.
Right. He didn't fill out, Your Honor. I spoke to him, and then I believe the prosecutors,
Well, yeah, this is their
advocates-
motion.
Right.
This is not his motion.
Right.
The defendant's motion to modify, the victim agrees to modification of the conversation.
Right, so she's in a domestic violence diversion, Your Honor. She's successfully operating on that and doing everything she needs to do there. When we entered into the diversion, one of the things the court said was with the children in common and the no contact order and the diversion being that long, it was going to create some problems. I spoke to Mr. Boucher, and he indicated that he either didn't want the order or would think about that and be okay with modifying or rescinding, but he would have to talk to the prosecutor. It sounds like he's okay with it being modified to allow contact to exchange the children, which is really the biggest thing, because right now they're allowed to exchange the children through a third party, but they don't always have a third party. So we would be asking that they be allowed to communicate and meet in person.
Is there a parenting plan? I'm trying to figure out the best or easy way to do it, say, as allowed by parenting plan.
Is there a parenting plan? So just,
And Your Honor, I'll read his note. He said that he would like a no contact order to allow child exchange at fire or police station parking lot. And he would like email and text only for purposes of children, regarding the children.
Does the parenting plan, I don't know, without seeing that, say that it's supposed to be done at the fire department or something? Or-
We are currently exchanging the babies at Costco. That's what the parenting plan says. Costco and
But do you have to have can you drive there and do it?
Yes, I can drive there.
under the parenting plan, but not under the current court order. So I would ask Your
So
Honor.
technically, then if she drove to how old is the child? They're young. Gave the child to him at Costco, you're having contact with him, because you could be in violation, so we need to alter that.
And we would ask, Your Honor, that it just allow contact for exchange of the children at any public location.
Okay. You shrugged your shoulders, that's all right with you?
Yeah, Your Honor, that's.
Up here.
Was there one? Yeah, I missed it. I didn't see her name on it. Is it?
No, I guess not.
So you wanted an actual order rather than well, yeah, I guess I can't. Can't do it, it has to be pretty much an order, other than she amended the conditions of diversion. She's on diversion, right? What are we gonna say?
Your Honor, could the order authorize a single civil standby for her to recover her property at the home? I don't
She
believe-
can't do a third party.
It has been that he will not give it, like, I will make a list of the things that I need, my personal property, and he will not give it to my third party. He will give half of it, just a few of them.
Your dissolution, then I guess you have to go back to court and hold him in contempt if he's not giving something that he's supposed to give you as part of the dissolution.
He has done it like 3 times. My family members and, church members has been there like 3 times trying to get my items, and he will not give him, he'll even withhold the baby's clothes.
I know, but doesn't mean he's gonna give him if you have a,
And Your Honor, was it child
civil
exchange
standby.
in public place and then, text and email for child purpose only?
yeah, where are we at?
So what do you have on the story?
I think the order already allowed any
Oh,
text and email communication.
So you need to tell me what it is, be
Okay.
specific, so the sheriffs know.
Second come up is, what was it?
I don't think there's really a need to protect him by way of all communication, so I think the order should allow the email and text communication. And it makes a record of whether or not there were any threats or anything like that.
Right, so the order did not previously allow for that. The order previously only allowed for third-party contact to retrieve personal.
Is there a
belongings.
catch-all name that covers all that?
Electronic communication.
Right, regarding child, for purposes of the children.
That's
They're the only thing with the third party. I haven't talked to him. He's the one that contacted me.
Okay, electronic and phone communication allowed. or children exchange, something like that.
Electronics/phone contact allowed for child exchange.
What else?
Yes.
So that would be, that's like what it is the 250 feet restriction. Or something, allow child exchange in public park.
Yeah, we have to have something, because otherwise she'd be in violation of the no contact with him.
So allow child exchange to be in any public location. Is that what you're asking for?
Yes,
So that's
and
it. It's electronic/phone contact allowed for child exchange and allow child exchange to be in any public location.
then the question I'd have, so you won't get in a bind,
It's the same.
does, just a second, does email included in electronic? I
Yeah.
think it is, isn't it?
Yes.
Okay. Email, text, et cetera, Facebook, all that stuff.
Is the court gonna authorize this in the standby?
Third
Oh,
part,
okay.
no, I'm allow, you can try third-party contact to obtain possessions.
Okay. All right. Thank you, Your Honor.
So again, and if you won't comply, you're gonna have to get a court order, or sue him, and you can see him in court and sue him in small claims for whatever you think he has of yours that he should've gave back and didn't, and maybe that'll get him to comply.
Yeah, we'll talk about that.
Mr. Lee,
Yes, Your Honor.
got a second?
What's that?
You leaving right away?
I was gonna stick around and do a few things.
We already had, so the only,
Give me a minute, I wanna,
so there's only.
I ran across
new
this
things.
old article that has your father's picture on it.
I would love to see it. I'll
I'm
stick
gonna
around.
get it.
I'll stick around for sure.
I said, it also had a copy of old Judge Bennett's picture on it, and I gave it to his daughter. It turned out it was 3 years before she was born.
Wow.
All right, if she can step over here and sign this, please, we'll get copies for everybody. Go ahead and sign.
What was the date on that?
These people
These
didn't
never
show,
showed.
so we're done. Just wanna mark on there.
Should I put on there?
No one appeared. Order remains.
Again, for the record, these people are not appearing. Haley Martinez. She filled out two, or she filled out one, he filled out one.
No, that person has two cases. The Martinez one has two cases.
Oh, I see, yeah, there's two numbers here. So that was her petition, but, so petitioner did not appear. Hey, your mom may.
Yeah, I just scanned a
Oh.
copy of it, so did you wanna keep this?
You can have it.
I can have it, okay, yeah, she'll, thank you, Judge, I appreciate it.
Yeah, it was fun. Or do you, remember Jed Fritzler much? Remember him?
No.
He probably didn't, when you came, he probably left. But
Yeah.
I guess those glasses were in style back then. Have you seen the picture of Fritzler?
Yeah, I saw Roger Bennett.
Yeah.
Yeah.
What was that, how long was that? 30 years ago?
85, 95.
Yeah.
Yeah, 31 years ago.
Wow.
Wow. I'm looking forward to reading it.
Yeah.